Good morning, good afternoon, and good evening, everyone. Thank you for joining us online. I'm Matthew Wilkinson, and today I'm joined by Sven and Isabella, and we're going to walk through the challenges of data protection in the new world that we find ourselves in today. We'll be taking questions at the end of the session. Please feel free to add them in the chat box during the session, or please reach out to us directly. I've been at Hawksford for over 11 years, and my role has two key functions. One is as Global Chief Technology Officer, responsible for technology, processes, and data protection. And the other one is the COO of Asia, which sits across our Asia offices. My key driver is to enable the business and to create the perfect environment where our professionals can work effectively together and efficiently across the world. We've helped thousands of leading multinational corporations, listed companies, SMEs, ambitious entrepreneurs from over 115 countries to grow and expand in Singapore by providing corporate services such as secretarial, accounting, tax, as well as other tailor-made services. We have over 200 highly qualified experts across Asia and 450 globally. Our people are highly experienced and diverse and have strong multilingual capabilities, covering over 20 nationalities and speaking 22 languages. Our experts bring over 10 years of in-depth know-how in Asia to offer our clients personalized service and providing quality expertise to access to the major economies of Asia. Our strategic solution is comprehensive advice and competitive pricing packages, also helping deliver substantial growth for your business. We have created GuideMeSingapore.com, which contains more than 1,000 comprehensive guides of up-to-date resources used by over 7 million people worldwide to navigate you through the complexities of doing business in Singapore. 2020 has brought us many challenges, but has also shown us how companies nowadays need to be agile and flexible, ready to adapt to a new environment. Our lessons we've learned is that we can adapt from working from home, and the technology underpins our business, but it comes with risks. Back in January, during Chinese New Year, when the outbreak started, I was called in to run the steering committee for China. Our priorities were very clear: to ensure the well-being of our colleagues, at the same time to enable the business to keep running securely without causing any disruptions in servicing our clients. Over the years at Hawksford, we have planned our business continuity tests annually across the globe to ensure that we're ready for the worst case scenario. However, I don't think we ever would have pictured a situation that's unfolded as it is today. From a technology perspective at Hawksford, we have a platform to enable remote working. However, home working brings itself challenges. One of them being your mindset. One of the key things we did in Singapore was to start rotation of working from home for all the staff in February to get everybody comfortable with their home setup. And as time moved on and the circuit breaker was brought in, we were ready for home working. This was a crucial decision we had taken. The main reason behind this was our experience of learning what had happened in China. We knew what had happened already, and we needed to ensure we was able to work remotely. Embracing this new way of working comes with challenges. It gives benefits for everyone, has different solutions and different situations for all our members. From a business side, it takes clear leadership and strong team management to ensure your team meets its goals and works efficiently. One key recommendation I'd make to you all is to get your teams to make a list of the pros and cons on the subject of working from home, so you can understand what has worked well and what has not. This is very useful to know. In a world where technology is everywhere and available to everyone, We also have to consider cybersecurity and ensure that our data was not only secure, but is able to be looked after at the same time. As information is now digital and cyber risks are now at the highest level. On a personal level, we are now more digitally aware with the use of technology to see our loved ones we can't be with and order our groceries online. And as we move out of COVID, we will have a very different workforce, which is more digitally aware than ever before. So we have to enable our workforce for the next chapter. Our values and responsibility for our data will remain the same wherever we are working. So it's our role to ensure we are built in the right digital and technology environment and infrastructure that, as part of our company, it needs to meet the 9 obligations set out in the Personal Data Protection Act, the PDPA. I would like to introduce Sven, who's going to talk you through how to enable your business and prepare for the future of your digital transformation. Thank you.
Okay, thank you, Matthew, for the interesting insights and on what challenges businesses are facing today, especially during this difficult situation. I will now tell you a little bit more about the cyber risks and threats and how complying to data protection regulations can help you to remediate those risks. But first, I would like to introduce our company and myself very quickly. I'm Sven Kreiter. I'm the Managing Director at WestGuard Solutions, and in the past I worked several years as an information security consultant and data privacy expert in Germany and here in Singapore. During this time, I helped our clients to protect their systems from criminal hackers on a technical and administrative layer. And this is usually done by attacking the systems to identify the vulnerabilities. So actually, I was officially allowed to hack all the big banks here in Singapore and in Germany as well. But actually, I started my career as a software developer. So I think you can see that I have a very deep technical background, and so have our consultants as well. So all our consultants are certified with the common industry certifications in the field of data protection and cybersecurity. Today at WestGuard Solutions, we support our clients to stay compliant with the data protection regulations. And our main service here is to provide an outsourced data protection officer. So we saw that many companies don't have the right internal resources or the big budget to spend it on expensive data privacy lawyers. So that's why we defined a special data protection service package. And this package combines consultancy manpower through online sessions and together with our digital data protection portal to meet all the regulations and requirements. And digitalization here helps us a lot to provide quality service and to also keep the costs down, but maybe more on that a little bit later. So we saw that in times of mass remote work, the risk of data breaches and incidents is increasing. But what actually are those risks we are facing here? Here are some real life examples of cyber attacks from the last weeks. So in the UK, for example, a construction business which is building hospitals had to shut down their systems after an employee clicked on an email attachment. So he was lured to click as the attachment was promising a new medicine for COVID-19. But yeah, in the end, it was no surprise that it just was a virus. And maybe you already have read it in the news that EasyJet got hacked and hackers stole their customer data. And now they are facing a big monetary penalty because a lot of personal data was stolen. And it seems they introduced some vulnerabilities when they opened up their infrastructure for remote work. And yeah, Zoom. I guess most of you got to know this online meeting software. Unfortunately, hackers were able to steal user Windows passwords, and they also managed to access private conference meetings. So this attack already got its own name, and it's called Zoom bombing. So the authorities here in Singapore prohibited to use the software for homeschooling. And actually, from a data protection perspective, I would also not really recommend this software, as the online meeting communication is not encrypted. The statistics of Q1 shows us that there was a huge spam mail campaign related to COVID-19 topics. So this is done to either sell fake corona medicine or face masks, or just to spread computer viruses. And it was also very suspicious that 20,000 new URL domains were registered lately with COVID-19 relating names. And these are also mainly used for phishing attacks. So here we see an example of how such a malicious spam mail can look like. They are promising the latest news or info about a vaccine, but the attachment is just a virus to steal your credentials or banking account. Very often, the virus first infects the endpoint laptop of the staff, as this is usually the weakest point in the chain, because maybe the antivirus software was not updated or not enabled. But then the virus automatically spreads itself within the internal business network, because the endpoint is connected via VPN to the company network. And as soon as it reaches the internal network, the virus tries to encrypt all the data, and you only get it back when you pay the hackers. Usually, in this case, not even a cybercrime expert can help you, because the data encryption is very strong. But we also see fake government websites asking for personal information and bank account details, or malicious mobile apps, which are actually banking Trojans to steal TAN values for money transfer. The WHO phishing website to steal user credentials is also very good looking and could generate many victims. And even the Facebook Messenger is used to trick users to visit, for example, a malicious website or to download a virus. So therefore, we created some guidelines on how you can protect your business from such attacks. So we already heard that the laptop of your employees is the most risky part in the whole infrastructure, especially when the company device is used from home, because the laptop might be used by other family members who don't know any policies. And in this guide, we outline some safeguards and measures to protect your business, especially during remote work. Here you can find different security controls for endpoint security, measures for your infrastructure, which is now opened up for remote access, and also administrative guidance in form of policy rules for your staff to follow during home office. For example, you definitely should define a list of tools which should be used for collaboration. So if you are interested in that, we share this information with you. Just let us know after the webinar for this guide. Okay, so now let us talk about the data protection situation here in Singapore and how the regulations can help you to protect your business. Singapore wants to keep its title of a first-class business hub, and that's why they introduced a data protection regulation called PDPA, the Personal Data Protection Act, to protect personal data. Actually, it already took effect in 2013, so quite a while ago, and it defines certain rules and requirements about how to collect, use, and disclose personal data of your users, your employees, and customers. So employees also counts as personal data and are covered by this act. And yeah, since 2018, the authorities started to take this act much more serious. And actually, they just announced 2 weeks ago that the financial penalties will be increased. And it all began with one of the biggest data breaches we saw so far here in Singapore. And maybe you also have heard about the SingHealth story. SingHealth runs several clinics, hospitals, and healthcare centers all over Singapore. And it is very common and as it is very common, they outsource their IT infrastructure to an external service provider. And the vendor was responsible to take care of the IT infrastructure and also its protection. But as you can imagine, it happened that their systems got hacked and the criminals got access to their patient database. And again, I guess you can imagine that healthcare data is quite sensitive, and 1.5 million patient data was stolen, including the data of many politicians, and also the Prime Minister himself was affected. This was the biggest data breach so far here in Singapore, and that changed a lot. So the vendor hasn't done a proper job. Then the investigation showed that the systems weren't patched and no proper access control was implemented. So the result was that the CTO lost his job and the company got fined with 750,000 Singapore dollars. You would now think that this was mainly the fault of the vendor, but actually SingHealth also got fined with $250,000 because SingHealth was the owner of the data, and under the PDPA, you need to do a proper due diligence before choosing an external vendor who is processing your data. So you cannot give away the responsibility by just outsourcing tasks. But sure, you can protect yourself by doing a proper due diligence process in advance. So this was the biggest imposed fine so far, but we also see that much smaller companies get fined when they don't comply. And this is no joke. The company name, the violation itself, and the amount of the fine is published on the internet, on the authority's website. So if somebody is searching for your company name, they might find this page. And so there's a real monetary risk. And there's also a reputational risk which you are facing when you not comply to the act. Here in this slide, we see penalties for not appointing a data protection officer or not having data protection procedures or policies in place. And the fines ranges between 5,000 and 20,000 Singapore dollar. Okay, so as we have heard about the risks now, I would like to show you what tasks and activities needs to be conducted to be compliant. Therefore, we need to dive into the obligations of the Act itself. But yeah, what is actually covered by the PDPA? So what is the scope of the PDPA? Yeah, we know that it is about personal data, but what exactly is personal data? The definition says that personal data refers to data with which an individual can be identified, like the name, the address or date of birth of the individual, but also their hair color or the gender counts as personal data already. We also separate sensitive personal data, which is data that even needs a higher protection level, like health data or financial information. And if you have a data breach with this kind of data, the fines will be even higher. To secure this personal data, the PDPA defines 9 main obligations, and each obligation outlines different requirements and rules or demands for certain procedures and measures to be in place. First, consent. Consent must always be obtained from your users before personal data is collected or used. Usually, consent is obtained by signing a contract, or we all know the checkbox in web forms to accept the data privacy terms. We also need to give the right to withdraw consent. So a process needs to be in place to make sure that the data is not used anymore. And to manage the consent, you have to keep records of all consents given or withdrawn. By the way, consent is also needed for CCTV surveillance. So a photograph of an individual also counts as personal data. And that's why we see all the yellow CCTV signs everywhere on the walls. So the easy rule here is whenever data is collected, obtain consent. Next is the purpose limitation. Before collecting data, you have to think about the reasons and purpose why you need the data. This purpose must be defined together with the data types that are needed to fulfill your service. And this definition must be written down. Here it is important that you only collect data types that are really required to fulfill your service. Don't just collect anything because you are able to do so. To know what data types you really need for your service, you need to understand how data is processed internally, where it is collected, where and how it is used, and to whom it is transferred to. So these are the questions you need to answer. Most companies doesn't even know how data is processed. And therefore, one of the most important things to do is to create a so-called data inventory map. So we provide a digital feature to easily create such an inventory. And this is done during an online session together with one of our consultants. The next one is the notification obligation. After you defined the purpose, you also need to notify the users about it before you are allowed to use the data. Quick example, that means you have to define the purpose and then you have to publish it on your website. Just a quick example where many violations were made lately was the COVID-19 visitor forms. When I went to a client, I always had to fill in my personal details into a form, but most of the times I haven't seen any purpose definition. I just gave my personal details without knowing what they will do with it. And I only saw a few office receptions which have done it in a compliant way. But yeah, given the current difficult situation, I think the authorities won't investigate such cases. But actually, this is a severe violation. Beside these rules, the PDPA also defines certain rights that must be given to the users. The right to access and the right to correct their personal data in your possession. Organizations are required to give access to their personal data upon user request, and therefore a certain process must be in place to grant the access. Usually, a communications channel is established via the data protection officer, who then verifies the identity of the requester, because if otherwise, you are risking to give the wrong person access to the data and you would already have your first data breach. And again, our data inventory is the basis to perform this process. So our data protection officer package includes a digital solution for such access requests. The PDPA also makes sure that only accurate data is processed, especially when a decision is made that could affect the individual. That can be done by counter-checking collected data, or you give your users the possibility to update and check their data by themselves through an online portal, maybe. But in the end, this obligation asks for reasonable effort to ensure accuracy. So there is room for interpretation what reasonable means on a case-to-case basis. Retention of personal data. If personal data is not needed for any business purpose anymore, it should be deleted and disposed. Therefore, you need to define retention periods for each collected data, and also think of secure disposal methods. A quick real-life example here: we have seen that an insurance agent just threw documents into the bin, and the documents were found by somebody who informed the authorities, and the result was that he got fined for it. So to comply to this obligation, again, our data inventory feature and workshop is the basis to define how long certain data needs to be retained. Quick question, how long do you think the visitor data of for COVID-19 purposes must be retained for contract tracing? So here I would say not longer than 2 months. So because if there is no COVID case within the first 4 weeks of the visit, contact tracing is not needed anymore and the data can be disposed. So you need to think about what are you doing with the data, and when comes the point you don't need it anymore. The protection obligation is my favorite obligation, and I would say one of the most important ones, as here we really think about appropriate protection measures and safeguards which should be implemented on a technical and administrative layer. The obligation just asks for reasonable security arrangements. And again, but what does that really mean? How do you know what needs to be implemented? Therefore, a risk assessment should be conducted to analyze your business processes and to identify risks and threats in your process. And you can then think of suitable security controls to remediate exactly those risks. Common security controls and measures are, for example, access control to prevent unauthorized access. That's usually done by authentication. Technical controls like encryption, antivirus solutions, or firewalls. We also have administrative controls like policies, and even physical controls to lock up documents or to lock office doors. Here we can support you with our TOM assessment, technical and organizational measures assessment, and our TOM catalog in our portal. Also very important is the transfer obligation. This one handles how data can be transferred outside of Singapore. When transferring data outside of Singapore, you need to make sure that the recipient is under a similar data protection jurisdiction in his country as under the PDPA here in Singapore. If that is not the case, you need to have contractual terms in place to ensure the protection of the data. And very important, you need the consent of your users. So you have to outline in your purpose definition that the data will be transferred. Usually the terms to protect yourself in such a situation are outlined in a so-called data processing agreement, which should be signed whenever data is disclosed or transferred to an external entity. So when do you actually disclose data in your company? Again, that is identified with our data inventory feature. Just an example, usually you disclose personal data of your employees to an external payroll service provider. So here you already transfer data and you need to make sure that the service provider has proper security controls in place. Another interesting fact, during COVID-19, the consent obligation is waived. So no consent is needed when disclosing data for contact tracing purposes, because here that's a health issue and the authorities have waived this obligation. And last but not least, the openness obligation. This one demands to, for example, appoint a data protection officer and to make the contact details of the DPO public, for example, on your organization's website. You also need to have data protection policies and procedures in place. And you need to educate your staff. And as you already can imagine, we also provide digital features for all these requirements. For example, we have a policy framework solution where we provide all the required policy and contract templates, as well as the data processing agreement, which is needed whenever you are transferring data. Newly added was the advisory about NRIC collection. I think all of you already wondered in the past why, for example, movie theaters needs your NRIC number when you purchase movie tickets. Or I also saw that you need to give your NRIC when renting a bicycle in the East Coast Park. So it was somehow common practice in Singapore to collect these identification numbers. But actually they can also be used for illegal activities such as identity theft or fraud. So since September last year, it is not allowed to collect NRIC numbers anymore. However, another exception was made during COVID-19, but only for contact tracing purposes. So you are not allowed to use this number for anything else. Okay, so that was a quick dive into the data protection requirements, and that was actually already my part. Thank you very much for listening to me, and I will now hand over the word to Isabella from Hawksford, who is the main contact person for the data protection services at Oxford.
Okay, thank you so much, Sven, for the insightful sharing about data protection, governmental regulation, interesting case studies and key obligations, and what we should cover to be in compliant and with PDPA. I'm sure that all of us all benefit from the knowledge shared. So interesting when you, in one of your case study example, you mentioned that if your company is engaging a payroll service provider, just to ensure this payroll service provider that they have proper policy in place. So Oxford, as a payroll service provider, and also we also provide other regulated financial professional services. So I just want to ensure you that we have proper policy and procedures in place, and we also have a dedicated data protection officer to be appointed. So rest assured that we are compliant with the PDPA. Just a little bit introduction about myself. My name is Isabella Xue. I'm the Senior Associate of Business Development in Oxford. As many of the organizations are more and more aware of the importance of being in compliance with the Singapore Personal Data Protection Act. So I guess the next question as a business, you may think that, so how do I ensure my organization meets the key obligations to avoid data breach scenarios? As one of the key mandatory requirements is for our organization to have an appointed data protection officer and have the designed policy framework. Obviously, you could appoint someone within your organization who understand the business and the Data Protection Act to fulfill this requirement. Or you could simply outsource this work to external professional data protection service provider like us. We know that getting the groups with the gap in your data protection policies can be time consuming, and this is something Oxford, together with WestGuard, we could come in to help. So if you choose to actually outsource this work to an external service provider and having an external professional data protection partner to assist you with being compliant with PDPA, such as you could have a lot of advantages, such as keep the cost low, as you don't have to train yourself or train your staff or meet the expenses of having to maintain a new headcount of a dedicated data protection officer. Obviously, Sven could share with you his experience of retaining dedicated talent like this. And that is where we come into place and present you this outsourced data protection package to get this covered, so that you could have a dedicated data protection officer to your organization with timely data protection management and report, so that you could focus on your expertise and with your business growth, with the assistance of the data protection officer, you could live a peace of mind knowing that your business is in compliance with the regulations. In this slide, I would like to quickly introduce you our services to help you comply to all the PDPA requirements. We have our outsourced data protection officer package, where a certified data protection expert will be appointed as your DPO. We also have already developed, together with WestGuard, the policy framework with all required PDPA policies and contract templates to assist you reduce the risk of countering the penalties. We also provide data protection awareness training for your staff so that they could be more cautious and prepared when the policies are coming into practice. You will also get a free access to a data protection portal where Sven has mentioned in his presentation slides earlier, where all of many of the services will be conducted via online section in this portal to meet with PDPA compliance step by step. In case the data protection is a quite bigger risk in your company, we also provide an advanced compliance assessment where we have data protection consultants come on site to conduct all the assessments and workshops with you. Of course, if none of these basic services that you think would suit your current situation at the moment, please do feel free to reach out to us, as we would love to hear from you, your thoughts, so that we could know how we could assist you better in this. We have also prepared some frequently asked questions. So I will be reading out the questions. Maybe the panel speakers could join me to give the answers. So the first question is that, do all organizations need to appoint a data protection officer?
I'll take this one, Isabella. Yes.
Thanks, Matthew.
Every company is obliged to appoint a DPO, regardless of how large or small the company is. Even non-profit organizations and startups and one-man officers must meet with the PDA requirements. So it's important and obviously obliged that you have one.
Okay, thanks, Matthew. And yes, we have also been talking about this, the importance of appointed data protection officer in our presentation slides. So yes, thanks, Matthew. So I guess the simple answer will be yes to this one. So the second question is that, does my data protection officer need to be a Singaporean resident? So maybe I could cover this one because I get asked question like this many times with my client. So the simple answer to this is no. You don't have to be a Singapore resident to be the DPO of your Singapore business. But just to add on, it is recommended to have this personnel fully familiarized with the Singapore Data Protection Act to implement the right policy in place. And this is also recommended for this person to be residing in Singapore, being at a Singapore time zone, so that they could give an immediate response and when liaising with the government authority when required, or on data protection request when required. Okay, so the third question is, does the DPO need to be a lawyer? So who would like to take on this one?
So I will answer that. No, actually, the lawyers are only needed for contractual tasks, but normally they cannot really help you in setting up your internal data protection framework, as they may not have the necessary technical and procedural knowledge. Nor do internal guidelines need to be written by lawyers. So furthermore, lawyers are paid on an hourly basis, and that can also be quite costly. So simple and short question, no, they don't have to be lawyers.
Okay, great. Thanks for that. So basically, just as shared in the presentation slides, it's actually, you don't have to be a lawyer to be the DPO in your organization. But again, I believe that this DPO needs to be familiarize with the Singapore Personal Data Protection Act, right, Sven? Okay, so the first question is that, yep.
No, go ahead.
Okay, so the first question is outsourcing the DPO to an external service provider allowed? This is a very interesting question.
Yes, so
yeah,
and this is also actually recommended because it is quite difficult to fill in this position internally very often, and most companies do not want to create a special dedicated position for it. So it makes sense to engage an external service provider to bring you to PDPA compliancy step by step.
Okay, so it is not only allowed, but also it is recommended. Okay, thanks, Sven. And also thank you, Matthew, for the answer. In the beginning of our presentation, we mentioned that we will be taking questions. So let me see whether we have any questions here. Okay, here we have a question. According to the PDPA, would smartphone or web metadata be considered as personal data? This type of data is commonly used for scoring and marketing efficiency reasons. Thanks.
Yeah, so that's actually already a quite special case and a difficult question. And the PDPA doesn't really cover this topic in detail, but still metadata is considered as personal data. So that's why in the privacy notices on websites, you read always, you can find what data types are collected, and the metadata is there listed as well. So you still need to protect the data, and actually you should give the same rights to the users as for any other data types. Still, here it is really a special case, and that's maybe a little bit more difficult to handle, but you certainly should protect it. Let me think a second. Yeah, because although it is metadata and you cannot directly identify the user of this metadata, still there are possibilities to take this data, combine it with some other data, and then you get the identification of an user. Because what is metadata? Metadata can be a signature of a user that you recognize him when he is visiting the next website. So although you cannot really identify the user individually, but you know that this is the same person, you know, you collect data about him, what websites is he visiting, what is his behavior in the mobile app. So that might be sensitive data, for example, if it is a health care data app. So although you cannot directly identify the person, you still need to protect the data, and the answer actually is that those data is also covered by the PDPA. Still special case, but you need to treat it the same way.
All right, thanks, Sven. So I think we will still need to keep those data being protected under so that to be in compliant with PDPA. So
yes.
Okay, thanks for the answer. So let me take a look to see whether we have other questions. So here is another one. Is there a time frame to follow the regulations to appoint a DPO?
Yeah, I can also answer this one. So yeah, you should. So at least appointing a DPO should happen as soon as possible, and better yesterday than tomorrow. So this is a mandatory thing to have. to implement all the requirements, this takes a little bit longer, and that can be done step by step. So the authorities, they don't want to see that you from one to the other day you just implemented everything, because that's just impossible. Nobody can do that. Certainly the most important things must be done very soon and very fast, and we can support you to take these steps. But then what the authorities wants to see is that you have a plan, that you know what is going on in your business. So with our portal, for example, we always have a management and audit dashboard where you see, hey, these are my gaps today. I know about them, and I have a plan to remediate those gaps in future. So I know what controls we're gonna implement. That can't be happen over one night. This is a longer process and a longer project, because some of these controls which needs to be implemented, it takes time, and maybe it takes months. Still, you should start as soon as possible to figure out this plan and to figure out where are your problems today. This is done by a gap analysis. So we do a PDPA assessment together with you to see what is your maturity. So what is already there, what is missing, how can you fill in these gaps, and the time frame, there's no exact thing, but you prioritize. So you know what is the most risky part, so where do you need to react at first, and then you're gonna implement these. But yeah, this whole process will this data protection framework you're gonna set up internally, this is an ongoing process, and you can improve it year by year. So there's no special time frame where you need to implement all of these things.
Okay,
still,
thanks, Sven. So
maybe to add in the end, still the consent obtaining and purpose definition, these are this is the basis that needs to be done as soon as possible. Actually, you are not allowed to collect data without the consent. So this is really something which needs to be implemented yeah, as soon as possible, because otherwise you have already here a violation, and your users, they can complain at the authorities. So there's an official site where you can reach out to the authorities and complain. So if you collect personal data and you don't notify the people, you don't obtain consent, you don't give them access, they can complain, and I can tell you that the complaints, they're taken seriously. So they will investigate, they will ask, what is your process, what is your plan, what measures are implemented, how do you obtain consent. So yeah, actually these are the main things which needs to be implemented immediately. Thank you.
Thank you, Sven. So I believe that you will need to actually appoint a DPO or be in compliance with the policy framework ASAP, because you might get exposure to the risk of being exposed of your personal data, including your employee or potential clients, and they might be scenario that they reach out to the authority and report you. So I guess the first thing that they should actually be, as an organization, they should probably do a full assessment to make sure that what will be their first step to be in compliance with PDPA.
Yes, so exactly, and I think we also have another very interesting question here. Maybe I can just take that one over as well. So the question is, can residents in Europe demand GDPR in data collected in Singapore? So maybe you already know that the PDPA is here in Singapore and governs the data here in Singapore from Singaporean residents. And in Europe, there's a very similar regulations. It's called GDPR. And if you have users or customers in Europe and you are processing their data, you need to comply to GDPR as well. Beside PDPA here in Singapore, if you treat their data, you also need to comply to the GDPR. And the good thing here is that it's all about protecting data and nobody is reinventing the wheel here. So the acts are quite similar. There are some slightly differences here, but still, if you comply to the PDPA, there are only a few steps left to also comply to the GDPR. And as we are actually, I have done this assessment back in Europe for GDPR already a lot of times. So usually for our clients here in Singapore, we also go through the GDPR requirements when we go through the PDPA and doing the assessment for the PDPA. But yes, so the short answer again is if you handle and process data of European users, you need to comply to the GDPR.
Okay, thank you, Sven. That is the interesting question. So I saw another one which is very interesting as well. So it is quite similar to the question asked just now. So the audience is asking, if we have a GDPR officer, can he be the DPO for the Singapore business? Sven, would you be able to cover this one as well?
Yes. So in general, yes, that should be okay. But he needs to make sure to adjust the GDPR requirements to the PDPA requirements here in Singapore. So as I said, there are slightly differences here, and the data protection officer in Europe needs to adapt the differences of the PDPA. And he needs to be aware of the requirements in the PDPA, but if he has the right resources to learn about it and to dive into this act, then the answer is yes, the DPO can also be the DPO here in Singapore for PDPA.
I see. So there are still a slightly difference between GDPR and PDPA. So I believe that this personnel needs to be also familiarized with the Singapore Personal Data Act in order to implement the right policy in place.
Yes,
okay.
especially you need to adapt it for the situation here. So the processes and some steps of the processes there is a slightly change what needs to be done. And for example, if there is a data breach happening, you need to report that to the authorities. So then you need to know which authorities you report that to. So yeah, you need to familiarize yourself a little bit with the PDPA.
All right, thank you, Sven, for the answer. Are there more questions from the floor? Let me just take a look.
Yes, so we have another one. Maybe I just read it. If companies have global offices but consolidate their personal data in a shared data storage on the web, which legal jurisdiction will apply? So again, in general, that's possible. But if you look at this from a point of view here in Singapore, and you will transfer the data. So still you will have, and it's if it is data of Singaporean residents, then you transfer the data and then you need to fulfill all the PDPA requirements. When the same data storage is used for European users, then you need to comply to the GDPR as well. So it always depends on your users and the data and the individuals of which you processing the data. So in this case, you need to comply to both jurisdictions. The thing is, again, the acts and the regulations are very similar. So it should be okay to, you need to adapt all the implementation controls, but there's something to do for sure. There you need to see where are the differences, how you're going to implement it for a Singaporean user, how you're going to implement it for a European user, but in the end you have to comply to both acts.
Okay, thank you, Sven, and for your answer again. I believe we still have a lot of questions that from the floor, but due to the time limitation, although we would like to address all of them during the section here, but if we are unable to get back to you at this section, do feel free to write your questions to us. Maybe we could arrange another private section with you directly. So again, on behalf of Oxford, we would like to thanks to everyone who participated in our data protection webinar today. And yes, I hope you find our sharing useful, and do feel free to reach out to us after the section. We will also be sending out a follow-up presentation slides to you if you're interested. Thanks.
Thank you.
Thank you.